Hey, it's Cava Faulkner with Cava Faulkner, Elk Grove Living Trust lawyer, Sacramento succession planning attorney. Thanks for tuning in to another edition of the Daily with Christine. So you are a trustee and you don't know where to start. So this video is for you if you have been named the trustee of somebody's trust and they have either become incapacitated or passed away and you have no clue what to do. So stay tuned because we're going to talk about first steps, what to do if the grantor of the trust is incapacitated and you have to step into a successor trustee role. Also, what you're going to do if you are the successor trustee after someone has passed away. Why it's so important to probably seek legal help as well as working with a CPA. And what are some of the things that people don't know about what they're going to have to do as the trustee or what they need to do as the trustee to get things started. Really what the job entails. So let's go ahead and get rolling. So if you have been named the successor trustee of a trust and the grantor, meaning I've got an itchy nose, the grantor of the trust has become incapacitated, then you'll have to step in and take over managing that trust on behalf of the grantor. Usually, depends on what the trust says, but usually there are certain things that the successor trustee during incapacity cannot do. One of those things generally is to amend the trust when it comes to distribution. So that means if a grantor has left assets to his children or her children, as successor trustee, you cannot come in and revise those portions of the trust to change who gets the assets. Again, depends on the terms of the trust, what powers the trustee has during incapacity as to whether they can make any amendments at all, or whether once the grantor becomes incapacitated, the trust cannot be changed in any way, shape, or form, and it is what it is. So your job as a successor trustee at that time is to really make sure that you have a clear picture on what assets are part of the trust and how to gain control of those assets if need be. So for example, banking, potentially real estate. You may or may not need to sell that piece of real estate during incapacity. Depends on what's going on. But you will need to have a new certificate of trust drafted. If the grantor has become incapacitated, they're no longer able to execute documents legally. So a new certificate of trust will need to be created showing that you are the new successor trustee. You will have to take that to the bank to allow you to have access to the financial account so that you can begin taking care of the grantor from a financial perspective. So your obligation during that time frame is always to the grantor. You do have a fiduciary obligation to wisely invest the assets if they are being invested. There is a reasonable investor standard that applies, and you shouldn't have any liability as long as you're acting in good faith to basically take care of the grantor during incapacity. Now, let's say you've done all of that, or maybe none of that applies to you because the procedure is a little bit different, but none of that applies to you and you are the successor trustee that's been named in a trust and that person has passed away. Many times people know they've been named, but they have no idea what the first step is. And so whenever I get a phone call at the office, like one of my clients passed away, I get a call from the kids or the successor trustee, what do I do next? I will usually tell them there's nothing to be done until you get the death certificate. And even before COVID, that was taking, 3 weeks or so. I imagine it might be taking a little bit longer now, but there's nothing that you can do until you actually have a copy of the death certificate. And once the death certificate is obtained, then that would be a good time to meet with an attorney. Sometimes it may be an attorney who drafted the trust, if that's convenient. The venue for the trust, meaning if anything needs to be litigated or go to court, hopefully it doesn't, but if it did, it is the venue where the trustee resides. So if the trustee resides in Southern California and the trust was created here in Northern California. If anything needs to be done in terms of the trust, if there is any kind of petition that needs to be filed, something wasn't done correctly, then the venue where the trustee lives is actually the appropriate venue, not where the grantor lived in Northern California. So that's good to know, that it's really meant to make life convenient for the new trustee. So the trustee steps into the shoes of the deceased grantor, and now their job is to understand what the trust says, to look at what the assets are, and to basically follow the instructions of the trust, meaning who is going to receive those assets, gathering all of the assets, and then retitling them or distributing them outright to the beneficiaries. So one of the first things I talk to successor trustees about is the fact that the successor trustee now represents the trust, and any attorney's fees that are associated with administering the trust are an expense of the trust, not the individual trustee. They're acting on behalf of the trust to execute the trust, and the trust essentially pays for those fees. Hopefully there's enough liquidity in the trust to be able to do that. So that's one good thing to know. You should not be paying out of your pocket if you can at all avoid it, but be using money in the trust to pay any professionals that you employ. Once the grantor dies, their social security number dies with them, and a tax ID has to be obtained for the administrative trust. And the purpose of the administrative trust is to receive all of the assets before distribution, because of course the government, our federal government, wants to track every single last penny of gain and expense during this transitional period. And so the administrative trust with a separate tax ID is how that is done. Now, I've had people try to do this before, go on the IRS website and obtain a tax ID successfully. Some have been able to do it. Many have experienced a lot of frustration, not knowing exactly how to answer the questions and complete the form. But you do need to get a separate tax ID for that administrative trust. Think of that essentially as being used for a new bank account. The successor trustee will take that new tax ID, which will be associated with the new bank account for the administrative trust, along with the death certificate and a new certification of trust showing that now the successor trustee is the trustee in charge, and they should be able to open an administrative trust bank account. Roll all of the money into that account, and if there's real estate, if it's going to be sold, sell it, put the proceeds of the sale into that bank account. The trustee is always obligated to either pay creditors of the deceased grantor or negotiate with them. So they always have to be mindful of having to pay creditors, both secured and unsecured, or potentially negotiate with them. And let's see. So probably during this time, they are going to want to work with an attorney and or potentially a CPA as well, depending on whether the person is married or not. There are specific tax elections that are time sensitive that many folks are not aware of. And if you miss the window of opportunity to make that tax election, it's gone. So very important not to miss those opportunities, especially if you're married and your spouse has passed away. You do have a 9-month window after death to claim the unused portion of your spouse's unified credit, the estate and gift tax exemption, but you only have 9 months after death to do that. So it's important that you work with someone who can help you do that. Usually a CPA would be able to help you. Sometimes attorneys can help you do that as well. I don't handle tax matters, so in my particular case, I would refer a client to a CPA to make those elections, those timely elections. And then the obligation is also to notify the beneficiaries. The beneficiaries are entitled generally to receive a copy of the full trust document so that they can see for themselves what's what. They do have a right to full disclosure, and the trustee potentially can be an adverse party, and so that's why the attorney who's representing the trustee represents the trustee, not the beneficiaries. If there's a dispute as to the terms of the trust, or somebody feels like they should have been entitled to something else, they may actually bring a trust contest, and go into litigation over some terms of the trust or something that they think they're entitled to. Maybe they believe there's other estate planning documents that exist and these should not be followed. So all sorts of crazy things can happen, but the attorney does represent the trustee. If a beneficiary wants to litigate, then they get their own attorney. Depending on the terms of the trust, the trustee can potentially pay themselves. Many do not, especially when they're family members, but sometimes if there's a protracted matter going on, if there's litigation pertaining to not just the trust, but some other type of litigation that arises or some complex matters involving assets, they many times can pay themselves and will choose to do so, but they'll have to account for that. And it will have to be deemed reasonable, and that is dependent upon a number of factors, including, sort of the going rate in the area, the amount of time spent, and obviously what the person does for a living. So if you have someone who's a brain surgeon acting as a trustee, they may be entitled to a higher fee than someone who works at McDonald's. All of those things would be considered, but there has to be an accounting, kind of like balancing your checkbook. What did you start out with and what did you end up with? How were distributions made? And that way you have a clear path from beginning to end, from the time the assets were tracked into the trust by the successor trustee through distribution, so that the beneficiaries can see every cent that was spent, including to creditors, attorney's fees, professionals' fees, and any payments that the trustee is making to themselves. They do have a right to have all of that information. So it's a lot, I know, and it can be overwhelming when you step into this role not knowing where to start, but that's a little bit of a roadmap into what you're looking at. Really depends on what the assets look like as to how long this process will take. It could take a couple of months or it could be years. So I've seen complicated cases go on for decades where their trust administration remains open to solidify and finalize litigation. That's usually the monkey wrench that prolongs administration. But I hope that you find this helpful, and just know that working with an attorney will take a lot off of your plate. I realize that it can feel overwhelming when you have lost someone and realize you have now this job to do that you know nothing about, but we're here to help. Thanks so much for tuning in, and if you do have this problem, we can help you with the trust administration, so reach out and let us know what's going on for you, and we'll take this burden off your plate for you. Like our video and subscribe to our channel if you like our content, and let us know what you'd like to hear about. Take care and have a great day. Bye-bye.